I'm Michael Large. I'm a solicitor at Grant Saw Solicitors. I qualified in 2002 and I've done all kinds of property litigation over the years. I did the King's Cross redevelopment before the Olympics and various other things. I've done about 200 or so residential possessions, so hopefully I know what I'm talking about. And the changes that came in October last year were the most drastic and, from a landlord's point of view, the worst that I've seen in the 12, 13 years I've been doing this. Seminar will briefly explain the procedure for obtaining vacant possession of a residential property let on an assured short-hold tenancy. Doesn't cover any other different type of tenancy you might have. It does cover the changes to the law from 1st October last year, and it's fairly recent, but I can give you an idea how that's been getting on since then. There are various new requirements to obtain and serve documents before a Section 21 notice can even be served. And what I mean by can even be served is it won't be valid. If you don't do all the various bits and pieces, jump over all the various hoops, you can put a piece of paper in the post or hand it to the tenant that says Section 21 notice on it, but when you get to court, the judge will just tear it up and throw it out. There is a concept of retaliatory eviction in the Section 21 notice, which is new, but we were all very worried about that. What's it going to mean? Not much in practice, so I won't spend too long on that. But if you don't follow, well, the thing to take away from here is if you don't follow all the procedures to do with serving a Section 21 notice, then you aren't going to get possession back for a long time. That's the thing to take away. I'm also going to very briefly deal with enforcing possession orders in the High Court, which is also bad news on that score, but there is some good news on the human rights front and in repairing liability, so we'll deal with that. And we all know hopefully what an AST is, assured short-hold tenancy. The changes that came into force 1st October only apply to ASTs entered into before that date. If you had a fixed-term AST that was entered into before then, and it rolled over, it became a periodic AST, it doesn't apply. As of 1st October 2018, though, year after next, they're going to apply across the board. So all ASTs, no matter how old they are, is going to apply. Landlords' repairing liabilities are in Section 11 of the 85 Act. We'll touch on that at the end, cheer us all up a bit. It's good news on that for once. And if you don't get a possession order to get rid of a tenant who won't go, you can't get rid of them. It's a criminal offence and a civil wrong to evict a AST tenant, or residential tenant, without a court order. So that's why we've got to go through all this. Evicting the tenant. Basics: provide a valid address in England and Wales. Isle of Man's no good. England, Wales, fine. Serve a notice, either a Section 8 notice or a Section 21 notice. We're probably all familiar with those, or both. All the nasty stuff I'm going to talk about, all the extra procedural bits and pieces, do not apply to Section 8 notices. Why that is, no real idea, but they don't apply to that. Section 8 notice is, of course, a fault notice, and a Section 21 notice is or was a no-fault notice, but now it has some fault bits shoved into it in a confusing and frankly unhelpful way. Once you've served your notice, issue proceedings, deal with any claim, counterclaim or defence the tenant has, get an order hopefully, and then enforce that using court bailiffs, either county court or high court. Section 8 notice. All the stuff about gas safety certificates, EPCs, electricity, God knows what else, that doesn't apply to Section 8, it's a fault notice. The thinking behind that escapes me. It's almost as if the government is saying, it doesn't matter how unsafe a property is, if somebody's been a bit naughty, it doesn't matter, we're not bothered. Not interested. If tenants got rent arrears, you don't have to have smoke alarms. It's a weird message that comes out of this, but that's the way the rules are. The most common grounds under Section 8, as we probably all know, are 8, 10 and 11, which are to do with rent, and 13 and 14, which are to do with tenants damaging the property or other general sorts of misconduct. My particular favourite under ground 14 is 14ZA, which is rioting. The tenant has been convicted of an indictable offence to do with rioting in England, which is lovely. In England, that is. So either in Wales they don't have riots, or they're not bothered about them. I don't know which. Usually, 99% of these are ground 8 of Section 8, which is the 2 months rent arrears, which we're probably all familiar with, which is a mandatory ground. Meaning, if you prove it, the judge has to give you your order and has no discretion in it. Those grounds, I'm not going to read through them all. No fault notice, Section 21 notice. That's a straight 2 months notice. It doesn't matter why you want to get rid of the tenant. It might be for some deeply unpleasant reason. It might be for no reason at all. You might not like the colour of their socks. Doesn't matter. 2 months notice, that's it. You might be wanting to sell the property, you might not. It makes no difference at all. 2 months notice. One of the good things about the changes that came in October last year is that all the old stuff in Section 21 notice about tying the end of the notice period in with a period of the tenancy. So if it was monthly and you charged the rent on the 25th of the month, it couldn't expire before the 25th, all that rubbish. That's all gone, thankfully. It's a straight 2 months notice, but make sure you give them some time for service. If you were serving notice, if you go away from here today and serve a Section 21 on somebody, 7th September, September, October, 7th November. That's no good, because by the time they get it in the post, they won't have had 2 months. So stick a bit of time on for service. I usually put a week on, which is overdoing it, but it means no arguments. Change that came in October was that you can't serve the Section 21 for 4 months. 4 months from the start of the tenancy. It used to be, best practice was, give them the tenancy agreement to sign, give them the Section 21 to sign, saying they've had it, off you went, straightforward. You can't do that now. You've got to wait 4 months and then do it. The tenant still effectively gets 6 months' notice, the end of the tenancy. What the purpose of that is, no one really knows, but there it is. That's the rule. You can, of course, use the accelerated procedure as you could previously, but you still have to comply with all the bits and pieces in the new rules. And if the tenant doesn't like going through the accelerated procedure, ticks the box, say we're in court, you're in court, as before. As before, Section 21 can't be served where you haven't complied with all the the tenancy deposit stuff, serving the prescribed notice within 30 days, all that kind of thing. That stays. We're all probably familiar with that. That's been around since about 2005 or something. If you're not, it's in the slides. As of the magic date of 1st October, there is on top of that a whole load of other stuff, which we'll get to shortly. The additional rules are contained in these lovely pieces of legislation, mainly in the Deregulation Act, which, considering it's called the Deregulation Act, has a hell of a lot of regulation in it, as far as I'm concerned, but there you go. As I keep hanging on about, they apply to all ASTs after 1st October 2015. Before that, even if the fixed terms expired and they're rolling over month to month, it doesn't apply. As of 1st October 2018, year after next, it will apply across the board. Something else to look out for, the smoke and carbon monoxide regulations, which aren't part of this. It's not entirely clear how they interact, but it looks as if you haven't complied with smoke and carbon monoxide, etc., regulations, and it's a new tenancy, meaning post that date, the court won't give you your order, even if everything else is fine. So, here are the rules. Notice in the new form, 4 months before you can serve it, they've got to live there, and you have to have done all these things, and you have to be not only done them, but actually turn up at court proving you've done them. So you have to provide the tenant with an EPC, those wonderful, useful documents we all love, gas safety certificate, which is rather more useful, this booklet, How to Rent, which is presumably in case the tenant suffers from insomnia, and as of next year, we think you're going to have to prove you've done all the electrical tests, the PAT tests, and all the rest of it. That's not in yet, but we think that's coming in next year. On top of that, you've got to have protected the deposit, which we all knew about anyway, and we're all hopefully doing anyway. In addition to that, and this is something courts are taking really, really seriously, I'll tell you about it in a minute, you need your licenses, and you need to turn up to court proving you've got your licenses, whether that's HMO license, selective license, whatever the property needs. You've got to turn up at court and prove you've got that. If you haven't got that license, and if you need it and can't prove you've got it, you won't get your order. Simple as that. In addition to that, there's this thing about retaliatory eviction, which hasn't proved such a big deal, but I'll take you through in a minute. And, of course, the smoke alarm regs. So, here's your shopping list. All this stuff. before you can get your order. And as I mentioned before, none of this applies to Section 8. So if your tenant's been naughty, not paid the rent, you can forget all this, chuck it out the window and serve a Section 8 notice. Again, what the reasoning behind that is, I have no idea. If there even is any, but that's the way it is. Retaliatory eviction, when it came out, sounded terrifying. That's a situation where tenant complains, landlord serves Section 21, which, as I mentioned, can be for any reason or no reason. And it was felt that landlords were using Section 21 to get rid of tenants who had legitimate grievances, and that was what they termed retaliatory eviction. This isn't as scary in practice as it sounds. If the tenant's made a written complaint to the landlord regarding the condition of the premises, and the landlord has not responded in writing and adequately, then the tenant can go off and ask for the local authority, local housing authority, to take enforcement action. And if all that happens, then you can't serve a Section 21. In practice, the time it takes the housing authorities to get around to doing anything about it is so long that hopefully you would have done it by then and got round to it. So all sounds very scary, but in practice hasn't really come to much. Licensing. The courts are taking this really, really seriously. I had a case last month, which was an old rules case, and the tenant didn't even turn up. The judge leapt on it and said, oh, where's your license? You're in a licensing area. You haven't got a selective license. We did have a selective license, I said that. Where's your license? And our barrister had to point out, well, Section 42 of the Act, it's an old tenancy, doesn't apply. We don't need to turn up with our license. And the judge was quite upset, actually, and disappointed. So, and this is a situation where the tenant hasn't even turned up to raise this point. So if the courts are concerned about this in cases where it doesn't even actually apply, you can bet that when it does apply, they're going to pounce on it. Again, I expect they're going to take a similar line with the smoke regulations. Slide here tells you what you need to do. I don't think we need to stand here worrying about carbon monoxide detectors, that kind of thing. Tells you what you need to do here. One of the oddities about all these new regulations and hoops to jump over is that if you haven't done all this, the local authority can fine you up to £5,000 and cause you all kinds of grief. The courts are not the regulatory body. They can't fine you. If you went into court and it came out of the proceedings that you didn't have your smoke alarm stuff, the court's not going to fine you £5,000. They don't have the power to do that. They might write to the local authority and say you're a terrible landlord and cause that sort of thing, but they are not the people who enforce this. And yet, they are having to look through all this stuff when it comes to possession claims. What the thinking behind that isn't entirely clear, because the courts aren't the police for this, and they don't have the powers to deal with it. Best they can do is give you a ticking off and refer you to the person who does have that power. So quite why we're having this duplication, no one's really sure, but there it is. A bit more bad news. Let's say you get your order and you are at the county court, you're jubilant, you've got that possession order in your hand, great, 14-day order, then I'll get the bailiffs in. It used to be that if you didn't want to wait 6, 8, 10 weeks till the county court bailiffs got round to you on their list, you could transfer up to the High Court and potentially, it's a lot more expensive, of course, as you'd expect, potentially get possession 48 hours after the date in your order, rather than 6, 8, 10 weeks. Great. This is now harder than it used to be. For one thing, the enforcement officers now have to give a week of sort of informal notice, so you're 48 hours out the window. And for another thing, the courts, for whatever reason, are not keen on transferring up. It's just become really difficult to do. They don't like it. If you do want to have a crack at it, what I would tell you is give the tenant notice in writing before the hearing, just a letter, say, at the hearing in a fortnight, I'm going to do this. Apply to the judge at the hearing. You can't do this under the accelerated possession procedure. You have to apply at the hearing. When the judge says no, which they probably will, you then have to make a formal application on Form N244. Just because the judge says you can't, you can still make that application. It's not the end of it's almost like an appeal. It's not the end of the road. You can still make that application. If there are things going on like rent arrears, drug use, place being smashed up, antisocial behaviour, whatever it might be, put all that in and ask for it as a reason why you should have that transfer and hopefully get possession in a week instead of 8 to 10 weeks. So that's all the bad news. There's quite a lot of it. Sorry about that. Don't shoot the messenger. Here's some good news. There is something nice for you. Well, I had to really look for it, but there is something nice for you in the Deregulation Act, which is London residential landlords no longer need planning permission before renting out short-term lets. Hooray! Great. So you got that. Bit more good news. Human rights. Does the Human Rights Act, all that stuff, does it apply to residential possession claims with a private landlord? And we can finally say, no, it does not. Hooray. As of July this year, case of McDonald and McDonald, it does not apply. The Supreme Court, what used to be called the House of Lords, held, I think, very sensibly, there are quite enough procedural safeguards, thank you very much. We've been hearing about them for the last 15, 20 minutes. You can't have human rights as well. So there's a bit of good news, if anybody runs a human rights argument. This isn't really to do with residential possession, but I stuck it in because I thought you need a bit of cheering up and have a bit of good news for once. This is repairing liabilities. Section 11 of the 85 Act, which I mentioned at the start. Case this year, also from July, of Edwards and Kurosami. And this related to a buy-to-let landlord who was letting a flat from the freehold, who's got a long lease. They sublet their flat, and outside the property, in the pathway leading up to it, there was an uneven pathway. And the AST tenant fell over on the pathway, which wasn't part of the landlord's demise. They just had a right to go over it. Fell over, injured themselves, and sued their landlord. So that raises a prospect, if you've got buy-to-let flats or any kind of property where there are common parts or parts you're not in control of, that raises the prospect of you being liable for things you don't know about on the entranceway, the pathways, the common parts. In that case, the tenant hadn't given notice of the defect. They hadn't written to the landlord and said, hey, that pathway's a bit dodgy. Something needs to be done about that. Nothing like that. Just one day, out the blue, the landlord hears, I fell over, I'm suing you. And the landlord had no right to repair that pathway, and they didn't know about it. And in the Court of Appeal, and this is the scary bit, the Court of Appeal for you guys, the Court of Appeal said, yeah, that's fair enough, the tenant wins. But I did say it was good news, because when it went up to the Supreme Court, they got rid of that. Said, no, landlord wins, you're not liable. The reason for that was quite technical, but it boiled down to a couple of things. First of all, the pathway at the front of the property, the courts held, couldn't be considered part of the exterior of the property. It was just stretching the definition too far. They did find that the landlord had an interest, so potentially they could be liable. You're not off the hook completely. The landlord had an interest because they had a right of way, so even though by finding that it didn't apply to the exterior, the landlord's won in this case, potentially they could have been liable. So it still leaves the door open for liability. And the next question that the court talked about, even though the landlord had already won here because they felt rightly it was important, was, does the tenant need to serve notice before the landlord can be liable? And in that situation, the courts held they did. The reasoning for that was essentially that where the tenant is in possession and has control of that part of the property, if there's a problem, they need to tell the landlord before the landlord can be liable for injury or anything like that. You've still got to fix it, folks, I'm afraid. The tenant writes to you and says, the wire's hanging off the wall, whatever it might be. You've still got to fix it unless you can prove they damaged it, but they have to give you notice before you can be liable under Section 11. The court went on to say where the landlord keeps control, possession, for instance, if there were common parts, but you have control of those, it's a different situation, the case we just heard about, or if you are in control of the exterior brickwork, you retain that as part of your tenancy, that sort of thing. If the tenant doesn't have the possession, the control of it, and then you are liable whether you get notice or not. So the stuff you keep in control of, you keep in possession of, you need to monitor that closely, because if the tenant injures themselves, if there's a problem, if there's damp, whatever it might be, you can still be liable, even if they haven't given you notice. But it's certainly not as bad as it would have been had it not got past the Court of Appeal, where any of those problems you could potentially have been liable for, and the first you would have known about it would have been when you got the solicitor's letter from somebody like me. There's the rioting bit, if anyone's interested. That's what it looks like. You can get it for free from the Department for Communities and Local Government website. You can get it from legal stations, whatever it might be. As I mentioned, even though it's straight 2 months, don't forget to put in something. If you're doing it yourself or your lawyer's doing whatever is happening, don't forget to put some time in for service. You might not be as paranoid as me and put a full week in, but do make sure you put the appropriate time in for service. 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 Service.